that is, which have the capability to intoxicate, whether they are drinkable by humans or not. But if your lordships take the view that liquor itself means only alcoholic fluids, then attachment of intoxicating to it will certainly have a different meaning, which may indicate that it has to be fit for human consumption. And Malaz, in my respectful submission, there are two broad cleavages: pre-synthetics 1990, that is pre-synthetics 2, and post 1990. And what is pre-1990, the meaning of liquor was what I am suggesting the court to adopt, which is also the meaning in Balsara. That is, it's all fluids, and therefore intoxicating only qualifies it to make all fluids which contain alcohol in any form. And synthetic breaks that meaning and form, and post-synthetic, some judgments have already been placed before the court, the meaning changes. And this Malot's error begins in para 70, if I may respectfully say, error of synthetics is in para 74 of the judgment, which is at PDF page 55. My lords will just have it. It's been shown.
We just saw it in the morning.
Yes. The bottom part, I'll just read it. Lordships will not go to it. The above entry contains words intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. So, the Supreme Court here goes with the Bombay High Court view in Balsara, not the Supreme Court view. And what does it say about the Supreme Court view, which is Justice Fazal Ali's view? The decision of the Bombay High Court is repeated in so and so. In that light, perhaps the observation of Fazal Ali J in Balsara case requires consideration. It appears that in light of new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is. And as such, when the word liquor was used by Fazal Ali J, they did not have the awareness of full use of alcohol as industrial alcohol. Well, just, if your lordships will just come to that, page 47, there's something which turns on that. I want to just...
Para 74, page 54, right?
Page 55 PDF, begins at 54, at 55 PDF.
So, Balsara dealt with a case of prohibition.
That's correct. But
prohibition for human consumption.
But
alcohol for human consumption was prohibited. Then it was challenged on the basis of Article 19(1)(g). Because if you have a complete prohibition, then such product is not available as a raw material for toilet preparation and for another, medicinal. Therefore, they struck it down on that basis.
Plus the words liquor and intoxicating liquor both were interpreted in that.
And for Mr. Balsara, to have prohibition would have been blasphemous, absolutely, you see.
That is another main aspect.
Of course, Balsara not.
Plus the Bombay Act, if I may answer, the Bombay Act contained the entire universe, including spirits of all kinds, varnish, everything. So the Bombay Act in that sense was the entire scheme of liquor, not just... That's true. It arose in the context of it. That's true. It arose in that context, but the interpretation was of the entire act. Page 55, PDF. Page 55, PDF. It appears that in light of the new experience and development. So
But can you just now, okay, this we have seen.
Yes.
How do you say that, the definition of liquor pre-synthetics would include all fluids? Of course, one is, of course, what, common sense. We always say liquor in coffee. Would you like to have just the liquor, or would you like the liquor with some warm water? They ask you all the time when you go down to Bangalore or when you go to Chennai. But they'll ask even the Attorney General whether he'll have some liquor, you see. But But is there something more substantial we are missing to show that liquor would mean all fluids?
Well,
I
that's-
mean, that was the conventional meaning.
So-
Forget Balsara.
So your lordships will have volume 1I. I have put all the dictionary meanings of all the dictionaries of the relevant time. The ones I could find. 1I,
Page?
it's page 1. PDF page 2. The first one is the Law Lexicon of British India 1940. What was prevalent in British India at the time? Well, I've taken the liberty of putting it all in one place. Liquor, a liquid or fluid substance.
Volume one.
1I, I for India. There are two meanings possible. The
In a
second,
more limited sense.
That's
and
right.
in its more common application.
So there were-
Spirituous fluids.
correct, your option is absolutely right. So there were two possible meanings, but this meaning which was there of liquid has always been there at the relevant time. And my submission is that liquor used in entry 8 is in the broader sense, which was prevalent at the time. It was a usage available at the relevant time. Today, if your lordships will go to dictionaries, just even if your lordships Wikipedia it, liquor equal to fluid bracket, it will say obsolete. Because nobody today uses. And we should not use our contemporaneous understanding of the word liquor and impose it on 1950s, my respectful submission.
It talks about spirituous,
Also,
not virtuous.
Virtuous, I also say exactly what struck me.
That's right.
So spirituous and not virtuous.
let's kindly have Webster's number 2. Liquor, a liquid substance, and then again, the examples are, it's also used in the second context of a alcoholic drinkable fluid, but it's also used as a fluid per se. And if you watch this, we'll go down to the etymology of it. Liquor effectively is from Greek, which means fluid. Sorry, Latin, which is essentially fluid. That's the true pure meaning of liquor. Now, obviously that meaning has evolved, but my respectful submission to the court is at the relevant time, one of the predominant meanings, possibly the predominant meaning was any fluid.
But then do we interpret the constitution in terms of its original understanding, or we understand it?
I'm so grateful. So, that's why I began by framing my argument as the semantic meaning. Your lordships will examine the semantic meaning. I'm not proposing an originalist understanding of the constitution. That's never been our jurisprudence anyways. But to begin with, your lordships will always examine the semantic meaning as it existed. Then your lordships, after having determined what the original semantic meaning was, expand it if necessary, change it if necessary. What synthetics does, it mixes up, it says language has changed, therefore I'll now superimpose that on 1950. For instance, sex does not include sexual orientation. Your lordships have included it. But your lordships did not say sex originally included sexual orientation through expansionist process. Your lordships did not change the semantic meaning. It remains intact. Your lordship says situation has changed, society has changed, therefore we will now bring this into. What the synthetics code does, it changes the semantic meaning. That's what I was reading at 74. It says experience has changed, liquor today means this, therefore this is what it is. Plus that in my respectful submission is not permissible. It is nobody's case that something has changed. So the liquor original meaning is any fluid. The constitutional originally envisaged any fluid, and today's situation has changed so that we need to bring in something else. That's not the way. They said the language has changed. And I'll place something on that. Well, there's a very good article by a Yale law professor, because in US, in Article 4 of their constitution, they use the word domestic violence.
Domestic?
Violence. That's actually internal disturbance. But in 1780s, the word domestic violence was in vogue. What they mean is internal emergency. Today we will associate domestic violence with spousal abuse. So the meaning of the word, your lordships will first determine what liquor meant then, what intoxicating liquor meant then, and then after that semantic meaning is clear, your lordships will interpret it further if necessary. That the synthetics court has not done.
By the way, Mr. Farasat, where did you get all these dictionaries as of 1950 from?
Malaz, I am grateful to the court. Actually, I use the judges' court library. Nowadays, they permit us. So, Malaz, yes, last 2 days, my colleagues went to the library and we could access it from there. So, Malaz, I'm really grateful to the court for that. So, your lordships will see So the meanings 3 and 4 are also there. Because then what, if your lordship will stay on this, kindly have page 3. PDF page 4. Borrowing from justice.
I passed.
First, we'll have PDF 4 of the same volume. Because I've tried to borrow from Justice Hidayatullah's concentric circle in the context of public order, national security, public order, law and order. And Mulaz, in my respectful submission, in our case, liquor is the biggest outside circle, which includes all fluids. Within that, you have intoxicating liquor, which is all fluids which contain alcohol.
Yeah.
And within that, the smallest circle is alcoholic liquor or intoxicating liquor fit for human consumption. Now, what Manoj, the synthetic sport has done, it has gone from liquor to really intoxicating liquor for human consumption. That middle thing has been missed out. So that's why I'm saying, how do we, if your lordships take a meaning of liquor, then your lordships will see what does it really qualify the word intoxicating. And then what is the effect of that? The effect of that is, let's say, Manoj, denatured spirit. What is troubling the court? It really is one thing which comes out of it. So for everything else, it's covered in entry 8. There is no other substantive entry for denatured spirit or alcohol. So that's the only thing which is plucked out suddenly and hangs in the general entry of industry. Well, why should that be the case, I ask myself. Especially if at the time when the constitution was enacted, one of the known accepted meanings of liquor was fluid, and intoxicating liquor does mean clearly that anything which contains alcohol.
In fact, the argument of denatured spirit is by the states.
Well,
Balbir Singh was appearing for Maharashtra because the argument is because even denatured spirit is capable of being renatured in certain cases.
that
Therefore,
supports
give us that power as states to ensure that there is no such abuse.
I'm grateful. So that supports my point, because it's not as if denatured spirit is a category which is independent and not interchangeable. That's all the more reason your lordships will give intoxicating interpretation which will include all alcoholic liquor.
All right, what else?
Well, just finally on that, the next is this article by your lordship's question, the Chief Justice's question on we are not शराब पी At your lordship, I'll just pay.
Suppose for a moment, just to test it, you don't accept this submission of yours. Can we not reach the same conclusion by saying that, look, assuming therefore that denatured spirit goes into IDRA, unless there's a notified order, the state's power under entry 33 is not taken away.
No, but
It will arrive at the same conclusion,
But
but
one
tomorrow the
caveat.
difference is Government of India can come out with a notified order.
much inferior
But they have
power.
not done it for the last, they'll not do it because it has not done it.
No, that's true. They have not done
India
it.
has,
That's a very.
India has also changed. I mean, there's nothing so great about industrial alcohol that the government has to regulate.
It's quite clear. It's possible they may not do it, but the nature of the power itself is different because this is constitutionally demarcated to me if I have it in entry.
That is
Whereas
dependent
then
on-
I'm dependent on their goodwill. I mean, that's really so. As a state, Malad, I would press your lordships to bring it in that. Although immediately it may not impact me even if it comes there, but then later on they can obviously bring in something, notify something, and I'm ousted.
I know, but also, now you have to also understand, IDRA itself is an anachronism. It's just survived, that's all. IDRA is one of those, it's one of those, License Raj acts, which has also the scope of the act has been reduced now. There's no expansion of IDRA entries. What remained has remained.
Well, that's quite true, but Malad, in
It's
the
like the
post,
controller of capital issues. It was a time when, when everything was so tightly regulated.
Effectively being monitored.
Yeah, of course.
It's not just an RPF law. There is a separate ministry.
Ministry.
Under Ministry of Commerce, separate jurisdiction.
Malad, I will only.
But Mr. Solicitor, what we are saying is IDRA is now not, we are not today in a stage of the economy where IDRA is being progressively expanded. It's now
Broadly, your lordships are on a broad,
on where the economy is going.
yes,
Well, I'll just say one thing in response to that, that when I was in the post-GST era, for the states, any available spaces
Are important.
are important. So that's why we would press in entry because most of those spaces have been given up.
All right, thank you.
Well, just one on that, just so that to elaborate, your lordships will have the article at page 4. And I'm just going to read one page out of it. This is by a Yale professor, Jack M. Balkin, constitutional law professor. It actually just states what our legal position in India, any event is. I mean, of course, in US, originalism is very expansive. We don't subscribe to it at all in that sense. But we do subscribe to it in the way he frames it, is my respectful submission. And your lordships will kindly have PDF page 8.
Which volume is it?
Well, this is 1I,
One eye. Same.
same volume. It begins, my lords, PDF page 8 with the first line, but fidelity. My lords have it. Regular page
Yeah.
7, PDF page 8. But fidelity to original meaning does not require fidelity to original expected application. Original expected application is merely evidence of how to apply text and principle. Each generation is charged with the obligation to flesh out and implement text and principle in their own time. They do this through building political institutions, passing legislation, creating precedents, both judicial and non-judicial. Thus, the method of text and principle is a version of framework originalism, and it views living constitutionalism as a process of permissible constitutional construction. The term original meaning can be confusing because we use meaning to refer to at least 5 different things: semantic content, practical applications, purposes of functions, specific intentions as associations. Thus, when we ask the meaning of equal protection clause, we could be asking what concepts the word in clause 1, clause point 2, how to apply the clause, the purpose or function of the clause, the specific intention behind the clause, or what the clause is associated with in our minds or more generally in our culture. Fidelity to the original meaning in constitutional interpretation refers only to the first of these types of meaning, the semantic content of the words in the clause. We follow the original meaning of words in order to preserve the Constitution's legal meaning over time as required by the rule of law. Otherwise, if the dictionary definitions of word change over time, their legal effect would also change, not because of any conscious act of lawmaking or even political mobilization, but merely because of changes in language. And this is the example. So, for example, when Article 4 says United States must protect the states from domestic violence, we should employ the original meaning riots or insurrections, not the contemporary meaning of spousal assault. So, I will conclude by saying that your lordships will examine first what the original meaning of liquor in 1950 was, and then we'll see what is the qualification which intoxicating offers. In our respectful submission, it contains the entire universe, and not was not just until 1990, right from 1873, when the first Bombay Act was passed, that's the earliest act, till 1990, even denatured alcohol is clearly included in intoxicating.
Really?
Till 1990, synthetics judgment, plus denatured alcohol is in effect included in intoxicating liquor. It's only synthetics definition which takes it a changed view based on the change in what intoxicating liquor means in society. So it is not as if it's something new to us. That was the meaning which prevailed from 1873. All Mr. Dwivedi showed you lordships from all those acts. The meanings was quite clear. It included everything, including denatured alcohol.
Thank you.
I'm extremely grateful. Ma'am.
Thanks.
Volume 1B,
For?
appealing for the intervener in IA number 237338 of 2023. Private individual
Who's
party.
the intervener?
Pardon, sir?
Who's the intervener? Last time you told us you are the intervener.
No, sir, I am not the intervener. I
No, last time.
Party,
His daughter was the intervener.
that is the private individual party, citizen of India and the resident of Uttar Pradesh. Miss Sheila
Miss
Sharma.
Sheila
Sharma.
Sharma.
Yeah.
Is she a teetotaler?
Pardon?
Is she a teetotaler? She must have locus standi.
Yeah,
First.
yeah, sir. Well, Lordship, I have the locus.
Teetotaler means chai ही पीते हैं.
Pardon?
Teetotaler means chai ही पीते हैं.
Sir, can I start?
Yes, yes.
How she is affected by the issue involved?
Pardon, sir?
How she is affected by the issue involved?
Yes, sir. We are talking about the industrial alcohol. And this industrial alcohol is many times for the direct human consumption. And I give the example, like in the cosmetic industry, the nail polish.
People drink clean water.
No, sir. Human consumption, when we using the nail polish, then it comes in the direct contact of the skin, and it is also the human consumption. We are wearing this cloth, it is also the human consumption. How can we say if we eat or drink anything, then it is the human consumption? The constitutional entry mention the word only the human consumption. That is not saying that we should eat, we should drink. So that's why, sir. Can I start?
Thought you were done and you made the point.
No, Learned Council, I thought you have completed.
No, sir.
So human
Only I am explaining my locus.
So human consumption doesn't necessarily mean that you have to eat or drink the product.
Yes, sir,
Then-
absolutely. So
Yeah.
can I start?
Yes.
Started.
The main issue is the interpretation of the section 18G of the Industry Development and Regulation Act 1951 with regard to state legislative power for the industrial alcohol. This is the main issue in this matter. So on the last page of my written submission, the last paragraph, I will read only four lines, and after that I will say anything. Mere existence of section 18G of 1951 IDR Act in the statute cannot out the competence of the state legislature to enact the legislation in respect of the matters falling under entry 33 of the list 3 of the 7th schedule to the Constitution. States' power to regulate the use of alcohol, which would include the power to make the provision to prevent or check industrial alcohol being used as intoxicant liquor, should be recognized. So, sir, we are talking here, this is the industrial alcohol. This is the non-industrial alcohol. But there is no way the clear-cut division. Denatured alcohol, intoxicating liquor, as I said previously, is also for the human consumption. Like as, sir, Lordship, in this courtroom, we use the spit polish. We use the spit polish on the wooden balls. In this spit polish, when we sit on the dais, we direct, you can say, in the skin. So that's why, how can we say many products of the denatured spit directly in the human consumption and some indirectly in the human consumption. That is the way. And also,
What is your,
pardon,
what is your name?
Dr. Vivek Sharma, sir.
So Dr. Vivek Sharma, you are saying that ये जो लिकर की बात हो रही है,
Yeah,
इसके लिप्स के साथ कोई संबंध नहीं है ना? यही कहना चाहते हैं, कंजम्पशन माने लिप्स के साथ संबंध नहीं है,
absolutely, sir.
है ना?
Absolutely.
समझ गया हम लोग.
The things are overlapping, not the clear-cut division of the human consumption.
Sharma ji, is the intervener also related to you or no?
No, sir.
Just the name is the same.
Yeah, yes, sir. Absolutely.
Achha, idea to.
And sir, with regard to entry 8,
Last point.
last point, with regard to entry 8, when we are talking about the intoxicating liquor, many times before 70s and 80s, we can see in the labs the spit lamp in the laboratories are used, and also nowadays also in the schools going children can use that. Many lecturers of that time and the students directly drink that.
Directly drink what?
The intoxicating liquid denatured spit, which are using to light the spit lamp. So that's why there can be no clear-cut demarcation. All the things are overlapping. Because sir, at that time in the village and the small towns, schools are available, but not the shops of the liquor.
Yes.
Can I start, sir?
It's not a hop, skip and start, you know.
You came to the last para of your
Yeah, yeah.
submissions now.
It is over.
Now we have completed. Now. Thank you.
I am
Thank
like
you.
concluding.
Thank you.
Ah.
Thank you, Mr. Channa. Mr. Attorney General.
Only one interjection, bro. He took the matter to the level of Mirza Ghalib. Now, Mirza Ghalib, when he was old, and he used to drink a lot, he said, "Go हाथों में जुम्बिश न सही, आंखों में तो दम है, रहने दो अभी सागर और मीना मेरे आगे। मैं उठा नहीं सकता हूँ, लेकिन मैं आंख से भी पी सकता हूँ." He took it to that level.
What a compliment from the solicitor to you, Sharma ji.
Thanks for the compliments.
That drinks a lot of lighter,
Yes.
lesser intoxication. Lordship, please. If we place some broad reflections on why the principle of controlled industry may have different implications at different points of time in a nation's history. If you switch over from a completely controlled economy to a relatively free economy, I suppose even in those circumstances, the need for controlling an industry will always be there, depending upon the implications which an industry may have or may not have on the people of the country.
Today, there may be considerations of defense or national
That's
security, which will
That's right.
require a controlled industry.
So what I was listening to him is old 1932, the ice company case in New York State Ice Company was a Lehman. So what is charged with the public purpose and public interest? So a process, an industry, a thing, a material, an object, any one of them, if they're charged with a public purpose or a public interest, then state will have an interest in dealing with it in such manner as the state may like to do. Therefore, entry 52(1) may have to be seen from that point of view. while we have moved away from a license charge, but I said the importance of control of an industry or a process or a thing or a material would always remain in the contemplation of the state, and particularly because Parliament will decide for the entire nation. So we're trying on the lighter side talking about intoxication, the whole historical aspects of intoxication. We are not talking about merely probably in one level, the bacchanalian aspect of it. The whole Greek word Bacchus, which is used also in Shakespeare's Midsummer's Night's. We call that the root of the riot of the tipsy revelry. So therefore we are trying to look at meanings from a constitutional point of view, which makes sense for understanding the distribution of powers and authorities. Very often, like for instance, the word telegraph. When the word telegraph was invented, they did not know telephone. But courts interpret telegraph to mean telephone. There you are supplying a meaning to the word by reason of an additional invention which has come into the world of science and technology, and human experience comprehends it, and therefore says, I'll give this meaning to the word telegraph. Like Article 25, I give a meaning to life and liberty. But it comes to terms and expressions which have scientific and technical meaning. The court will not supply a meaning in the abstract. It can learn a meaning or pick up meaning only from the experience of technology and industry. So, regardless of the fact that all liquids containing alcohol may be brought within the broad term of a liquor, the constitution makers would have thought that why don't we use the expression liquor? Why resort to intoxicating liquor? Liquor would have been the most easiest expression because that's how common sense, industry, everybody understood it. But an intoxicating element is brought into it. One must ascribe some relevance to that addition to the word liquor. I'll come to it a little later, trying to break some broad reflection. How do we go about it? Very often we have this problem about definitions. Therefore, we are looking at a thing which is being defined, a liquor, intoxicating, which is the thing. And definition of a process or a matter or an idea or a principle. The definition of a word is different from a definition of a thing. A thing is defined by reason of its characteristics, features. A word is defined by what it is can convey over a period of time. So if you're looking at definition of intoxicant as a thing, I may eventually try to probably expand this, saying that the reliance on gas and gas works picked up from out of industry. Intoxicant as another illustration of picked up from industry. It will be valid up to a point, but not beyond a point. And if you're looking at the entire distribution of powers, we understand that the legislative entries are not exhaustive of what Parliament or a state legislature can do. Whatever came into the imagination of lawmakers at a given point of time were brought into these broad enumerations. So today we don't have a public, for instance, public premises was not an entry under anyone's list. And Parliament had to amend the Parliamentarian Salaries and Allowances Act to bring in pension, because the entry is only about allowances and salaries. So the mere fact that certain entry or a matter is not specifically enumerated in any of the list would not come in the way of the respective legislatures to go about legislating and acting in terms of out of a necessity to deal with the matter. Therefore, we don't say that List 7 schedule is completely exhaustive of everything, and something which is not there will fall here or there. I'll presently take your lordship through my written submission. Before I thought I'll do that. Therefore, this whole way of understanding the seventh schedule will be on the basis of what a state out of a necessity would be persuaded to legislate or embark on a course of action. Therefore, the necessity element will always be built in entry 52 list 1. Entry 33 could not have been brought in list 3. If Parliament thought that by bringing in the concept of a industry under union control was sufficient to deal with all matters relating to union control, then it could have ended so. So is there a purpose in saying that both Parliament and the state will have a concurrent competence under entry 33? And if so, what purpose will it serve? Either it must serve a new purpose or serve a purpose already in existence and expand its use or its exercise.
But, entry 33, Mr. Attorney, is a clear example or clear indicator that even while giving to Parliament the power to declare an industry, the control over which by the union is in public interest, the framers did not want to oust the jurisdiction of the states completely. Because
I don't propose to say that.
Yeah.
The very
Because
fact
that's
is
why
the concurrence.
they felt that no, notwithstanding the fact that the industry is declared as a controlled industry, production, supply, distribution, trade and commerce will be the subject of a concurrent power. So Parliament may override the state, it may not override the state, but the state was also given a power, even though the industry itself is a controlled industry.
Absolutely. I mean, there's no doubt about that. The very language of entry 33.
The extent of control under entry 52 of list 1 is itself in a restricted area. It at least excludes trade, commerce, production, supply, distribution, which is taken to list 3.
We can probably draw a wall of separation between a product of an industry and trade, commerce, supply, distribution, or we look at them as one continuum of activity, an economic activity of production, and thereafter supply, distribution, etc. We are looking at an economic activity. So there are many economic activities today which may end with merely production, but I don't think today somebody will make sense to say, I will produce, but I will not supply. So every production implicitly includes within the activity of production, the next series of actions. Trade, commerce, supply, distribution. They are a continuum of economic activities. So that's why even in entry 33, I'll come a little later about explaining it. In entry 33, clause A, it talks about the products of any industry.
Right.
The products, plural, number 1. Any product of any industry, as many products of any industry. So the products of an industry here means in a very expansive sense. In respect of those products of the industry, what is the scope of entry 33? In respect to those products, there can be a trade, there can be a commerce, there can be supply, there can be distribution. So therefore I find there is a symbiotic relationship between entry 52 list 1 and entry 33 list 3. You cannot see them in isolation. And I don't think Parliament would simply say, I will enact a law under entry 52(1) with a mere declaration that it is in public interest. No law would probably do that. It will go further and say, how will I achieve the declaration? Therefore, entry 33 and entry 52, if they are to be seen as two branches of one family. Is another way of looking at Would Lords kindly turn to volume 2B
Submissions?
of my written submissions.
Volume 2B. Oh, like just.
Where is this article? I've placed another extract from a book, which is volume 4D. I'll come to it a little later. Just Lordships make a note of that. It's one of the interesting treatises on linguistics in volume 4D. That's the title of the book is Meaning of Meanings. Before I go to that, let me come to my written submissions.
Let's see proposition 1.
Yes. So entry 52 list 1 has a special significance. Its scope is not controlled by any other entries. I say including entry 8. Entry 24 list 2 contemplates state control or regulation of industries within the geographical frontiers of a state. Then entry 52 provides for control aspects from a national perspective. Such a federal control will be based on principles uniformly applicable to all states as far as control of an industry and to serve a national interest. Several national and public interests are perceived to be served by federal control, namely subserving the common good, equitable distribution, fair prices, utility of products of industry, for serving the interests of all the states, etc. The common control element under entry 52 list 1 is an independent subject and is not a matter carved out of the subset of industries under entry 24 list 2. If, stopping here for a minute, if 24 and 52 dealt with distinct classes of industries, one can understand that. Entry 52 is an entirely different subject. It's about bringing industries under union control. The union control is the subject of entry 51, entry 52. Probably it is too stretching to say that from 24, the roots of entry 52 come. They occupy a different space, they serve different purposes, but even in entry 24, what would a state do in respect of industries? When we talk of a thing, we talk about how do we go about regulating the use of the thing, the consumption of a thing. When we talk about industries here, we talk about regulating the industry. So industries even at a 24 is about regulation. It's not anything other than regulation. So 52 is different. Regulation from national perspective. Entry 24, para 5, on the other hand, stands on a lesser pedestal, namely the geographical area. Regulation of industries that we dealt with under entry 24 is district. Entry 24 contemplates the competence of the states to enact and to provide all matters in respect of industries. Entry 52, on the other hand,
the reason why they argued that entry 52 is a carve out is because the subject of industries is contained in entry 24 of list 2. Because entry 24 of list 2 says industries. Entry 52 says industries, the control of which is declared by law by parliament. Now, which are those industries? Those industries are otherwise comprised in the subset of 24. Everything falls in 24, but once Parliament declares by law, that is abstracted out of 24 and then taken to 20 and taken to 52. That's the way it operates. It's not that industries in 52 is independent of 24.
My proposition is the subject of 52 is about union control.
Yes, of course, there's no difficulty about that. That you're right.
The union control is the subject there.
That you're right.
Therefore, Parliament could have, Constitution could have said industries can probably be in list 1, but that would not have made sense. In the sense that states will have to look after processes, manufacturing processes, industries within their respective geographical areas. So it is not probably correct to say something is carved out of 24, but entirely a different subject, namely union control of all that can be conceived as industries. So it's different significance altogether.
But 52 doesn't say industries which have a trans-state location or a trans-state operation. It says industry is the control of which.
Even industries within any 1 or 2 or more states, even they can be brought under control under entry 52(1). It depends on the national interest which industries may serve.
Suppose the IDRA was not enacted. All industries will then fall under which entry? Not under entry 97. They'll all fall under entry 24. Suppose an industry is not declared as a controlled industry, even after the IDRA is enacted. Where will that industry fall? It will fall under entry 24.
Article 248, for that matter, says it gives competence to the Parliament to enact laws which are not found in entry 1, list 1 and list 3. So therefore, the competence of Parliament to deal with certain matters. Can you look at Article 248 for a minute?
Article 248 is on the same lines as entry 97. Entry 97 is a residuary entry, including anything which is not found in any of the lists.
Entry 97 only captures that the element of Article 240, but 248 is the source.
So the ultimate residuary power is with Parliament. But it's nobody's case that Parliament is using a residuary power here. It's a specific power in the entry 52.
Not enumerated in the concurrent list or state list.
So that is plenary power.
Therefore, the source of parliamentary power is wider than, let's say, even 97, something which state list fine, Parliament can still enact it. So concurrently it's a state list, see 248. It is not in the state list. Therefore, the absence of an entry in any of the list would not make a difference. As a corollary, if the lists have a certain meaning and also, let's say, a connotation. Parliament cannot say that, look here, I don't look at the intoxicating part of it, I only look at the liquor part of it. Maybe Parliament can still do that. I'm just giving an example. Therefore, the entry 52 competence list 1 is something which is untrammeled or unconditioned by any other entry in the 7th schedule. Why I wanted to say that is this, whichever way the court may look at entry 8, whichever way one may look at it, will not control entry 52 list 1.
There is no question of control.
The Calcutta Gas Company judgment has been relied upon to show that we have 3 entries in list 2. Gas and gas works, intoxicator, and probably what other entry, namely fisheries. I tried to find out what would probably be any other entry which can be taken out of or treated as a subset of industries. We find these 3 entries there. One probably would think that the reason for a gas or gas works or fisheries or intoxicating liquor to be treated as a separate entry One of the reasons can possibly be that a special and attention is required to be bestowed on these things and on aspects, which otherwise, under the general entry 24, the state can easily achieve the same object. If industries means regulation, control, supervision of trade, commerce, supply, distribution, you can't probably give a narrow meaning to the word industries in entry 24. So if it has all the plenitude of meaning, a state can even at 24 achieve the same object of controlling, regulating, supply, etc. But if there is special attention to be bestowed on a particular subject, for reasons of the historical significance. So if from 1880 onwards, liquor has had a meaning, particularly with reference to the portability part of it, the human element part of it, the consumption part of it. For gas and gas works, if we did not know prior to 1935, the manner of production of gas and the new industrial use of gas, etc. It was a certain understanding on the historical meaning given to gas and gas at a given point of time. Therefore, there are 3 or 4 entries in list 2, which are specifically taken out, if one may say that, out of industries for certain very special reasons. That by itself does not mean they would not otherwise come within the scope of industries. In Calcutta Gas Works, the analysis by the court that there is a possibility of contributing 2 entries in the state list. And having in mind the 1951 Act, if there is a control element brought in there, look at what should happen to the state law. I'll come a little later to why Calcutta Gas judgment may probably require the reconsideration. May just go to my second proposition, number 2. And to give a symbolic or metaphoric, these entries in the 3 lists are not like the Berlin walls. They always have an interplay. And one can jump.
But suppose no declaration is issued by Parliament in a law under entry 52
Yes.
in relation to an industry. Under what list will that industry fall?
No, it need not be, it not fall under any particular entry anywhere.
No, it has to
That's
fall
what I'm saying.
somewhere.
That's
It has
what
to fall
there's an
somewhere.
industry. Today there's an industry which is not in any other list or even or not.
Suppose there's no declaration issued by Parliament in respect of a particular industry, industry A.
Yeah.
Where will it fall?
No, that inquiry, from my understanding, that inquiry may or may not be relevant wherever it falls.
No,
I'll just come to that.
relevancy we'll decide later, but suppose a declaration is not issued by Parliament.
If a declaration is not made under entry 52 list 1, then entry 24 will certainly operate.
Right.
That's not the problem. But the question is, entry 24 operating ex proprio vigor, right? In the absence of a law under entry 52 list 1, that may have no relevance to what the Parliament can do in entry 52 list 1. It may be an industry under 24, whatever be the industry. But 52 occupies an entirely different, issue altogether, subject altogether. So whatever be the industry, can Parliament not control it? So it is not it is the nature of the industry, as I said, the various purposes that will be served by controlling the industry. The moment you enter into discussions on what are the other entries in state list, which may have a bearing, a relationship or otherwise with entry 24, and therefore will it control entry 52 list 1? I think that's a long line of inquiry. We begin from the wrong side. This is untrampled, as I said. So if tomorrow Parliament says, I don't need an Industrial Development Regulation Act, and so be it. But as long as the law occupies the field, And Parliament has continued to say, well, I will insert various industries in the schedule. It evinces an intention to have a union control principle in position and to bring in from time to time industries within the schedule. Please come to page 3 then. Proposition number 2. Certain entries in Schedule 7 constitute a family of entries in as much as an element of interconnectedness between them exists. Entries falling within such a family cannot be seen in isolation, and in a sense they are complementary. Entry 52 list 1 and entry 33 list 2, 3 should be, is such a family of special class. The principle of control enunciated in entry 52 of list 1 can also include and touch upon all matters relating to an industry that is brought under union's control. These matters can be production, trade, commerce, supply, distribution, etc. Depending upon the nature of the industry to be controlled and the public purpose such control of the industry will serve, Parliament can deal with any one or more or all of the above mentioned aspects of the industry. To the extent that the Parliament may deal with these matters, the competence of state to legislate under entries 26 and 27 of list 2 will be excluded or deluded. Entry 33 of list 3, however, is a coordinating branch of the principle of control. Trade, commerce, production, supply, and distribution of commodities or products are interconnected aspects of an industry. Entry 33 contemplates that Parliament will have the primary competence of legislating in relation to any one or more or all of the above matters as may be deemed necessary towards the control of an industry. The primary competence dimension flows from the control aspect, the foundation for any further legislative exercise. Depending on the scope and extent of parliamentary legislation providing for control, the subjects which are not occupied by parliamentary law will be available to be dealt with by the states. When I say the primary competence of legislating, therefore entry 52 flows into entry 33. Then para 5, the view taken in paragraphs 14 and 15 of CL Union of India, suggesting that a division between entry 52 list 1 and entry 33 list 3 does not offer a correct view on the reading of the above said entries. The aforesaid paragraphs are extracted hereunder. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in entry 24 would not take within its ambit trade and commerce or production, supply, and distribution of goods, which are the express province of entries 26 and 27 of list 2. Stopping here for a minute, I suppose 24, 26, and 27 are a family of entries. 24 talks about industries. Once an industry, an industrial process, a production happens, everything thereafter is the continuum of an economic activity. For the purpose of felicitation and easy dealing with those matters, 26 and 27 are subdivided. Even if 26 and 27 are not there, 24 can still take care of all that under 26 and 27. Let me read paragraph 14 again. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in 24 would not take within its ambit trade and commerce or production, supply and distribution of goods, which are the express province of entries 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade and commerce in our production, supply, and distribution of the products of those industries, which fall under entry 52 of list 1. For the industries falling in entry 52 list 1, these subjects are carved out and expressly put in entry 33 of list 3. So what I find there is what I call the Berlin Wall. No, So 52 and 33 are so interconnected. They carved out, I say, for the facility of a state dealing with the subject. Let me read paragraph 15. In Calcutta Gas, the Judicial Court in Tikaramji was relied upon. Tikaramji is the case the court inter alia considered the interrelationship between entry 52 list 1, entry 24 list 2, and entry 27 list 2, and entry 37 list 3 as it stood prior to its amendment and is amended. This court examined the contention. The term industry should be widely construed to include all activities, including activities preceding production, such as acquisition of raw material, and activities subsequent to production, such as disposal of the finished products of that industry. Negativing this content in the light of the legislative entries, this court held that what would fall under entry 24 of list 2 would be the process of manufacture or production, except where the industry was a controlled industry, when it would fall within entry 52 of list 1. The products of industry would be comprised in entry 27 list 2, except where there are products of a controlled industry, and they would fall under within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and entry 20 of list 2 would not be covered by entry 24 of list 2. And similarly, the subject matter falling under entry 33 would not fall under entry 52 of list 1. At one level, it is correct, but at a different level, it is not. Because the entry 33 is not about union control of industries. But what happens along with union control is what is stated in entry 33. So union control must mean something beyond mere union control. It must mean the aspects and dimensions of union control. Therefore, I find in this reasoning in CL some kind of a wall of separation, which probably is not the adequate way of reading entries within the same list. Since I would like to make some submissions with regards what happened in Calcutta Gas. So if entry 24, 26 and 27, they all fall in list 2. So there is no need or a necessity for suggesting a conflict between these entries. They may overlap or there may be some distinction between these entries. In Calcutta Gas, what the court came close suggesting there's some kind of a conflict between antithesis between entries 24, 26 and 27. Or gas works and entry 24.
27, they have to yield to entry 52 list 1 or entry 33 list 3 as the case may be.
That's true.
So they have to yield.
That's true. I'll come to it immediately. But what I'm trying to find out is entries 24, 26 and 27 in the state list. If I call them a family of entries, it's only a distribution of a certain dimensions or facets of economic activity amongst them. Industry, trade and commerce, supply, distribution, as I said, to repeat, a part of an economic activity and interconnected. Therefore, as I said, for facility, suppose you only want to do a deal with trade and commerce in an industry, you may do it under entry 26. You want to deal with supply and distribution, you may deal with it under entry 27.
Should be declared this first. The entry 52.
That's right. As far as they are being subject to entry 33 is a different issue altogether. Because I had some difficulty in going ahead with the reasoning in CL. Therefore, I'll come back to it a little later.
33 list 3 is also with regard to a declared industry. That is the common thread.
That's right. That's right. Let me now continue to read at page 5, PDF page 5, paragraph 6. The reliance in the above judgment on Tikaramji for his conclusion does not seem to be correct. As stated above, entry 52 list 1 and entry 33 list 3 are two branches of one tree and they reinforce each other. On this understanding, the further conclusion that can be drawn is that it is open to the Parliament to enact in respect of matters relating to trade and commerce, production, supply and distribution, and also deal with the necessary elements of control and regulation touching upon the above subjects. The Industry Development and Regulation Act 1951 has enacted in respect of and provided for aspects of control and regulation touching upon trade, commerce, production, supply, and distribution. For the purposes of exclusion of competence of states from entering into any one of the above matters, namely production, etc., it is sufficient that the 1951 Act has touched upon the area and the nature of control and regulation vis-a-vis the scheduled industry. Then a law is said to be complete and made insofar as it contains all the essential features of a legislation, including provisions in relation to delegated legislation. The mere fact that the details of the working of the legislation may be dealt with by way of rules, regulations, notifications, I was reading at paragraph 8.
Yes.
The mere fact that details of the working of the legislation may be dealt with by way of rules, regulations, notifications, and orders cannot be the reason for the assertion that the law is incomplete or that the field is unoccupied. The enforceability or otherwise of a law by reason of non-emanation of the subordinate legislation can have no relevance to the actual occupation of the field in question. It is the occupation and not its enforceability that matters. Not speaking at all or silence on a subject is different from the absence of measures towards enforceability of the statute. Then Tikaramji was a case dealing with raw materials not falling within the scope of the scheduled industry. It was in that context that the court noticed that no order was issued by the central government in exercise of the powers vested under Section 18G. Because sugarcane as a raw material did not fall under the scheduled industry, the court felt that possibility of an order under Section 18G being issued by the central government would not be enough. The case on hand is no parallel to Tikaramji. The entire fermentation industry has become a scheduled industry. After the amendment in 2016, one part of the fermentation industry, namely so-and-so, continues to be a scheduled industry. As a result, the subject matter of the fermentation industry as a whole or otherwise stands within the scope of the 1951 Act and within the details of Section 18G. It's submitted Tikaramji principle cannot be said to be a principle of universal application. That is, in the absence of an order under Section 18G of the IDR Act 1951, it will be a dormant law and the states will derive their competence to deal with any matters or any matters otherwise exhaustively dealt with by Section 18G. In other words, since the 1951 Act has enacted in respect to the entire spectrum of control and regulation, and also the details of their working, for instance, as spelled out in Section 18G, the said Act, there is no unoccupied field at all available to states. Then proposition number 3. Why entry 8 of list 2 cannot be of any avail to the states? The litmus test of entry 8 is from the point of human factors, namely human consumption. The word intoxicating must be seen only with reference to the impact owing to human consumption. That which is not consumable by humans will not fall within the meaning of intoxicating. Entry 51 talks about human consumption, but in a different context. I'll come to entry 51 in a short while. So notwithstanding the long history of definitions of liquor to include liquids with alcohol content, it cannot be canvassed that a human consumption part can be kept aside. All uses of liquids containing alcohol, other than meant for human consumption, would all fall under one heading of non-potable alcohol. Even entry 51 of list 2 talks about alcoholic liquors for human consumption. It's immaterial that there is no entry in the 7th schedule specifically designed as industrial alcohol. The 2016 amendment by way of substitution of entry 26 of the first schedule to IDR Act 1951 must be taken to clarify this position. The reason for focus on intoxication and human consumption is not far to seek. The manifold increase in the uses of alcohol-based products was neither known nor contemplated while legislating with reference to liquor, save prior to and at the time of enactment of the Constitution. The focus was on temperance, regulation of trade and commerce in humanly consumable alcoholic preparations.
Like an intoxicated bee.
Let's put some fireworks in the meanwhile.
Think of the bee and nothing else.
No, they deleted it.
These are like some footnotes.
It just fell off, on the table itself, it just fell off.
Yes.
So I thought that it was being a little heady with all those words. Today, when I made that comment of intoxicated bee,
Yes.
they thought that now the man has also become. Intoxicated by your arguments.
I think that is intellectual stimulus rather than intoxication. So you go heady sometimes by reason of the home state, the fire in the theater. Right? You get intoxicated by some thought or an idea. So paragraph 4, the last line. The focus was on temperance, regulation of trade and commerce, and humanly consumable alcohol preparations. If I'm not wrong, therefore, I think when it is open to the legislature to pick up any of the definitions in various statutes, British and pre-independent, they could have picked up liquor. If liquor conveyed the same meaning on various classes of liquids with alcohol, with different impacts, with different consumption processes. I suppose in 1888, when the Spirits Act was there, nobody thought of using it for a toilet or a medicinal preparation the way we are doing it today. So the manifold uses which liquids of alcohol in different combination, strength, etc., can be made or put to use is something which emerging science and technology invents and discovers from time to time. Therefore, the Constitution could have said liquor, and it had the same meaning. But at some point of time, I suppose, when more and more understanding about the use of liquids containing alcohol come within the fold of experience, then it's open to Parliament or the statute authority to amend it, modify it, or in a given case where it's possible to give a meaning, as I said, telegraph includes telephone, the court may give a meaning. But where it is not possible, the court will not supply that meaning by itself. So it has to be based on the experience and knowledge which flows into technology and engineering and science. So that's why I thought this our argument on reading entry 8 narrowly or expansively may or may not have any relevance on entry 52 list 1 and entry 33 list 3.
So we have to give a constitutional meaning.
Yeah, yeah.
A meaning within the constitution means a constitutional meaning, not a meaning in the business sense or anything as such.
Right, correct. Let's try to take it a little further. So if I given a very narrow meaning to entry 8, to mean only that which is orally consumable. So that which is orally consumable can be an intoxicant. If you go back to the word toxic, even in Latin, toxicum, poisonous. But we can't go to that stage. So therefore, when all these legislation, the pre-British and the pre-constitutional legislation, they probably talked about what is the impact on temperance, oral consumption, what deleterious impact it may have on human consumption. Therefore, it's in that context, regulation of trade, supply, distribution, etc. But even if we read it very widely, now because we are talking about manifold increase in the in liquids containing alcohol, even if you give that manifold, taking into account, give that very expansive reading, I say whichever way one reads that, it's immaterial for the purpose of entry 52 list 1 and entry 33 list 3. They cannot control what Parliament would say and how do I bring it within union control for what purposes. The entire argument is look at Calcutta Gas Works. What did it do? It kept gas and gas works out of entry 24. The same thing you should do as far as entry 8 is concerned. Entry 8 will have a very expansive meaning. So the parallel, I think, is probably looking at the wrong side of entry 52 list 1. And therefore, I was trying to find out whether whatever be the concept of industries under entry 24, 52.1 is in a different footing altogether. But at the same time, there is some kind of a connectedness between 24 and 52 because they are talking about industries. So the industrial processes. So industry ultimately, whichever way one decides for the purpose of Industrial Disputes Act, or even otherwise, an organized activity by reason of which a product emerges. Something emerges out of an organized activity. That's why labor, capital, plus whatever one may call. So we have the theory of surplus value flowing from that only. So organized activity leading to emergence of a product or a thing or a matter. That's an industry. So when you want to deal with that as an economic activity, then I will look at various facets of that economic activity. So essentially, industry, in my understanding, is an organized economic activity, which is susceptible of being controlled under entry 24 and to a different level under entry 52 list 1 because of a national considerations. May I just quickly, in the same volume,
Syrup which has
because even yesterday, sorry, Mr. Attar referred to a judgment to the US Supreme Court on intoxicating liquor. Earlier there was a Master kindly, you can have a copy. Only.
that's constitutional sense.
The 18th Amendment was enforced between 1919 to 1933. You were copying that. 18th Amendment, Lord Habit. Let me just quickly read that. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquor. This here.
Oh, yes.
Manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes is hereby prohibited. The Congress and several states shall have concurrent power to enforce the article by appropriate legislation. That is what entry 8 is about. Then on the right hand side, now we have the 21st Amendment. Some slight changes here. The 21st Amendment reads like this. The 18th article of amendment to the Constitution of the United States hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquor in violation of the laws thereof is hereby prohibited. So what the 21st Amendment thought was the relevance to beverages may or may not be relevant because it's talking about intoxicating liquor as the one common element both in the 18th Amendment and the 21st Amendment. I've looked into all those case law under the 21st Amendment. They all talked about various interstate movement of intoxicating liquor as beverages from one state to state. So the beverage idea is oral consumption of a liquor, wherever that oral consumption by an industrial process or by any human process makes it possible. At that stage, it is humanly possible to consume a liquor. At this stage, the intoxication dimension of oral consumption comes into play. Otherwise, why would you talk about intoxication at all?
So something which is used for industrial use cannot be a beverage, though it may be consumed otherwise.
There are non-intoxicating
It's
beverages.
not a beverage in the normal sense.
So we are not talking about non-intoxicating beverage, but in beverage, the moment it has an impact on human frame, mind, body, whatever you may call that. Therefore, the intoxication element is the only necessary and essential element of looking at entry 8. But as I said,
Beverage.
even if we give a very broad and expansive meaning to intoxicating liquor, taking into account the various classes of liquids containing alcohol, denatured, whatever one may call them, industrial alcohol, if we give a very broad meaning, even thereafter, entry 8 will not be a springboard for the state to argue entry 52(1) cannot indirectly come and enter into a field in state list. Then we will employ pick and substance, entrenchment, etc., etc. I don't think that's the way of looking at entry 52, list 1 at all. We just quickly take your lordships to, I have set out in the next few pages, 8, 9, 10 onwards. Picked up those paragraphs in various judgments from Balsara onwards to give how the thought process in comprehending liquor, intoxicating liquor, has received a broad understanding in notwithstanding certain shades of difference in different judgments. Let me quickly take your lordship through that. We have Balsara you also have page 8, the PDF page 8.
Yes, we are with you.
Then we have Balsara on the right hand side. I have this. After examining various definitions in various provincial acts, concluded the framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in various excise acts of the country, and accordingly it was concluded the word liquor covered not only those alcoholic drinks which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. That's the broadest meaning possible. I mean, I'll skip synthetic and chemicals now. I'll come back to it later. Then, if you come to serial number 3, which is subsequent to synthetics, State of VP versus Modi Distillery. Look at what this judgment says. So it says, in the light of experience and development, it was necessary to state that intoxicating liquor meant only that liquor which was consumable by human beings as it was. I don't think it will be necessary for our understanding of entry 52 or 33 to get into this very detailed discussion on what classes of liquids containing alcohol exist and which one of them are consumable or not consumable. But if the court were to give that meaning which entry 8 would necessarily carry, having regard to the use of the word intoxicating, probably the court would be asked to stretching entry 8 to such an extent that the court would like to efface out the word intoxicating altogether. You can't by any reading of intoxicating say, I will efface it out. So if there's only 1 or 2 or 3 meanings of intoxication, then that meaning which I'll have the more core element for entry 8, but that meaning will be probably the meaning which the court will take into account. Kindly now come to page 14. Entry 8 of list 2 cannot be taken to be the point of anchor for determining the scope of entry 52 list 1 or entry 33 list 3. Entry 8 does not cast any shadow on the above said entries. The ITC ruling was in the context of overlapping entries or in the context of the doctrine of pith and substance for the purpose of comparison of two legislation and locating the dominant purpose, etc. In the instant case, there is no room for suggesting that the state legislation or the rules made by it or within their competence and that the field in relation to fermenting industries was unoccupied. As stated above, the 1951 Act is a complete code by itself and has dealt with all matters referred to in entry 33 of list 3 and relating to the fermenting industry. It is submitted the ITC judgment cannot be any parallel or of any assistance to the instant case. Having said that, may I invite your Lordship's attention to the judgment in Fateh Singh, which is
Volume 5B.
Volume 5B, 5B, yeah.
PDF 554.
PDF 554. Which paragraphs you want me to read?
Then,
Sorry.
Article 10 is also an indication how intoxicating drinks which are injurious to health. Naturally, it means something which is natural drink. Intoxic. It can't be an alcohol.
The possibility of an intoxicating liquor
Not industrial
having
drinks.
injurious elements.
Yes. But it should be a beverage
So that mischief is based
for
on maybe,
human consumption.
that's it, that mischief will be the subject of the law. So if it is a non-intoxication element of a liquor, it can be controlled under industries. So therefore, the connection between 8 and 24. 8 is not simply something which is taken out of 24 as an industrial process, but as a subject by itself, as a thing. Liquor is a thing to be dealt with. Yeah. This is the PDF
544.
554,
5B.
volume 5B. 5B. The discussion was
Fateh Shah.
about Gold Control Act
Fateh Shah.
versus the Maharashtra Debt Relief Act.
Justice Krishna Iyer.
Which?
Paragraph 2 sets out the factual context.
Money lending is not trade.
That's right. Against the virus of the Maharashtra Debt Relief Act. Then focused on Article 301, etc. Then
Right? 77.
at paragraph 5, and then after at page 558, discussion, another short, lethal objection to a part of the law. There was legislative incompetency for the state legislature because it had forfeited the power to legislate on money lending where gold loans were involved since the parliament had occupied the field under entry 52 list 1 by enacting the Gold Control Act 1965 and thereby elbowed out the state legislature from that field. We'll talk more about the elbowing out as we look into 33 and 52. Now, next.
77.
Page 577. Sorry. Kindly
Okay,
turn
we'll
to
wrap up
paragraphs 54. I'm so sorry.
You'll be wrapping out today. So that then on Tuesday we
don't-
can hear the.
I don't think I may have a little more time.
Just see if we can wrap up because we've now got the drift because your submissions are very precise.
Yes.
So we've got the judgments we can make a note of and, we'll look at them over we have this long weekend coming up.
Very well. I may take maybe some judgments where I need to give some explanations and commentaries because I find this Calcutta gas and Valsara present some possible way of looking at it, which is being repeatedly invoked to say that this perspective is the correct perspective. So,
Right. What if
otherwise, my propositions, in fact, come up the whole.
clearly covered, your perspectives have been covered fully.
Yeah. We'll also kindly turn to paragraph 54 at page 577. What then is the incompetence of the state legislature? So-and-so urged that the wiping out of private debts which form the capital assets of moneylenders, when the main thing done by the Debt Act was not in any of the legislative lists, and even if Parliament had residuary power under 97, the state had none. Entry 30 in list 2 is money lending and money lenders, relief of agricultural indebtedness. If common sense and common English are components of constitutional construction, relief against loans by scaling down, discharging, reducing, so and so, so and so, will among other things fall squarely within the topic. And that in a country of hereditary indebtedness and a colossal scale, is a commonplace the state legislative heads must receive large and liberal meanings and the sweep of the sense of the rubrics of must embrace the widest range. Even incidental cognate matters come within their purview. That's what we normally say. Now turn to para 55. The next ground of attack in his multiform presentation is that the gold loan part of Debt Act is void because Parliament has occupied the field. It's also been heard that there is inconsistency between the Debt Act and the Gold Control Act, and pro tanto, the former fails to have effect. Let us look at the basics of the legal situation before us, before examining the wealth of learning counsel has accumulated. Article 246 vests exclusive power for matters enumerated in list 1. State legislatures enjoy power topics list 2, so and so and so. Plainly, therefore, the state can legislate upon any entry in the state list. We may visualize situations where parliamentary occupation may exclude state legislature, where, for instance, Parliament, while enacting on a matter in the union list, makes as it is entitled to make necessary incidental provision to effectuate the principal legislation. Such ancillary extensions may trench upon state field in list 2. In such a case, if the state makes a law on an entry in its exclusive list, and such law covers and runs counter to what's already been occupied by Parliament through incidental provisions, we argue that the state law stands pushed out on account of the superior potency of parliamentary power in our constitutional scheme. Again, there are certain telltale heads of legislation in the list where one may possibly invoke the doctrine of occupied field. All that is stated here. Now, skipping entry 52 list 1, Parliament in the Industry Development and Regulation Act has made the necessary declaration contemplated in entry 52 and has occupied the field of gold industry, as is evident from reading section 2 of the first schedule therein. This expression of parliamentary intent to legislate upon the gold industry is enough to expel from the field the state legislature. This is Nariman's contention. But what's the sequitur? Assuming the appropriation by Parliament the power to legislate gold, what follows? It can make laws directly on the industry and ancillary and every allied area, but effective exercise of the parliamentary power necessitates. So much so, business in gold, licensing of gold merchants, regulation of making of pledging gold ornaments, keeping of jewelry, disclosure of gold possession, and the like are incidental to the parliamentary power and purpose of the Gold Control Act and the rules made thereunder. Several sections of the Act, some rules and a few rulings, were read before us to drive home the point that gold loans are already within the ken of the law made under entry 52 list 1, if so what. That is spelled death sentence on the Debt Act or maintain it or leave it intact. Here we turn to entry 24, the list 2, which runs industry subject to so and so. This means that the state legislature loses its power to make laws regarding gold industry, since entry 24 list 2 is expressly subject to the provision of entry 52 list 1. This does not mean that the other entries in the state list become impotent even regarding gold. The state legislature can make laws regarding money lending. Even gold is involved in entry 30, entry 34, gambling in gold, impose sales tax on gold, entry 54, regulate with municipal laws under entry 5, trade restrictions entry 26, type of buildings for gold shops, etc. To multiply
This part goes
instances
against
easy.
you. This part
But
goes
the matter-
against you, actually. This part goes against you, Mr. Attorney General.
I'll just.
That once there's a declaration under entry 52, it is abstracted from entry 50, entry 24. But the state can still legislate under the other entries which are not subject to.
But it may also depend on whether the law controlling it is fully occupied a space or not. That's a different exercise altogether. Then paragraph 59. They refer to Kanan Devan Hills, paragraph 58. This court put the point tersely while dealing with entry 52 of union list. How possibly the federal structure is balanced this judgment is an authority. So if you look at how the court looked at any other aspect which may have a relation to gold, but not gold as an industry, that is in paragraph 59. This authority for the proposition that while entry 23 of list 2, in the light of the fact that entry 52 of list 1, Parliament has made a Gold Control Act, has become inoperative to legislate on industry. There is no inhibition whatever in state legislation on subjects other than that particular industry. Money lending is one such subject, and the power to legislate thereon remains intact. So the attempt made here to say that entry 8 is other than industry relating to liquor or a fermenting industry would fall under this test.
Para also 60.
Paragraph?
60, the next one.
60. That's it. We are free to agree that the word industry as a legislative topic has to be interpreted in the widest amplitude. We also find that the fact that dealings in gold, including pledging, have been covered in part with the Gold Control Act. Even so, nothing prevents the state from making the impugned act. That's because about money lending.
Correct.
In Paresh Chandra Chatterjee, so-and-so dealt with an apparent continuity in the Central Act, the Tea Act and the state legislation, the Assam Land Acquisition and Acquisition Act 1948. After examining the scheme of the two laws, the learned judge concluded, a comparative study of both the act makes it clear. Two acts deal with different matters and were passed for different purposes. So, what is the purpose that we served by the state acting under entry 8? Because entry 51 in list 2, which enables the state to impose excise duty or any other taxes. So we are not concerned with that aspect of the matter. That aspect of regulation of an economic activity stands in an entirely different field. But any other aspect of regulation. So the entry 8 would probably enable the state to deal with any other aspect of regulation. They are in the realms of trade, commerce, supply, distribution. And they're so important because it keeps in mind, as I said, the impact on human consumption of liquor that may have an intoxicating effect. Whatever be that liquor, it is immaterial.
In that case, there is no conflicting entry, like entry 8 of list 2. In that case, there was no entry corresponding to entry 8 of list 2, right?
That's right.
Who is this that now that we are rising,
You know,
maybe you can give us for the remaining judgments, Calcutta Gas, and the other judgments, just a half
I'll
page
do
note
that.
each, and you can
I
tender
only-
it.
I only want to read a couple of judgments and to have first some commentaries on it. And I would have done it very
What
quickly.
we can suggest is we'll close now here, and you can give us just maybe 2 pages of the
I'll do that.
judgments, so that then we don't have to trouble you then again.
I'll do
Thank you, Mr. Akinwumi. So, Mr. Solicitor, then we'll start on Tuesday with your submissions.
Yes.
Tuesday night.
No, I may require about 10-15 minutes to just complete the narrations.
Just give us, writing,
No.
2 pages, 2 or 3 pages.
I'll review it in writing and read it out, subject to your lordship's permission.
Tamil politics for a long time. It is a politics that was based on vulgarity, especially the DMK politics. Kalinger Karunanidhi, for whatever we speak about him, he walked, he travelled, he slept in the roadside areas. He travelled, he took money, 1 paisa, 10 paisa, 1 rupee, 2 rupee. That's how the 1949 to 1967, the growth happened. Udayanidhi Stalin comes. Cinema actor, golden spoon, comes in the ivory tower. You speak the same language, I am going to annihilate Sanatana and Dharma. That is why you see the revolt. Anybody in Indian politics should learn from A. Rajaji how to do politics. When he's on the back foot, when the corruption is coming on him, he doesn't want people to talk corruption about him. He will shift it to Sanatana Dharma. That I will not wear a skull cap. Neither will I tell my Muslim friends to wear a vibhuti. Because if I wear that skull cap for that 110 microseconds because I have to come in photo to say that, oh, you are my friends, I don't want to be that kind of politician. And saying that, oh, Modi ji doesn't wear a skull cap means Modi ji is anti-Muslim. That should be the biggest joke of 21st century. When somebody says, I am going to cut PM to pieces, you want me to answer rationally, madam? Oh, no, sir, you can't cut PM to pieces. He has got SPG security. He has got 4-layer security. You are such some small man in Tamil Nadu. You don't even belong to the dirt that is in Modi ji's nail. So please move away. I have to reply in a certain way where they have to make sure next time the same language should not come in their mouth, madam. Tamil Nadu, when the political change has to happen, you have to defeat the ecosystem. The candidates are mere tools of an ecosystem. And Coimbatore is one such seat where the ecosystem is at play. 2019 was not a great year because the message was mixed. And our language and our alliance partners' language were very different. Modi ji is an opening batsman. He has hit 6s and 4s. And he has given you 200 runs, he has gone. And again he'll come back. But 150 is you have to score.
How many seats do you see?
Madam, if you want to ask me a number, I would say double digit, very honestly.
Why is it that your party members always make fun when Rahul Gandhi goes to the temple?
You cannot become an Amar Akbar Antony just before elections. And people read through you. You become an Amar in one state, Akbar in one state, Antony in one state, depending on which state has got a character.
Namaste, Jai Hind. Welcome to another edition of the ANI podcast with Smita Prakash. Thank you for liking and subscribing to the channel and sharing the conversations with people who you think will benefit from listening or watching these conversations. My guest today is no stranger to the ANI podcast. He featured in episode 35 in January 2023. Annamalai Kuppuswamy is now contesting the Lok Sabha elections from Coimbatore. Annamalai, former civil servant turned politician, is the youngest person to become the BJP's president in the Tamil Nadu state unit. The state sends 39 members of parliament, and for decades now the MPs are from AIADMK or DMK, with the Congress and Communists having marginal presence. Polling for 39 Lok Sabha seats will be held in the first phase on April 19th. The BJP did not win a single seat from Tamil Nadu in the 2019 Lok Sabha elections. But now it's Annamalai all the way round who's drawing attention. So let's see what's in store for Annamalai and the DMK. Congratulations, Annamalai sir. Thank you for coming to the podcast.
Thank you.
Now, between last time that you were here and this time, there is so much difference in your career path. The Padayatra has happened, and now the battle for Kovai. So it's going to be like Dravidian parties all out, making it a prestige battle. Annamalai has to be defeated at any cost. How do you see this battle?
Thank you, madam. The room hasn't changed. You haven't changed. ANA hasn't changed. It is still the same excellent organization. Thank you for giving me one more opportunity to come here. Very happy to be here. Madam, firstly, I should thank the party for nominating me as a Karyakarta from Coimbatore. Of course, Coimbatore has become a very important battle now. And I'm seeing the social media from yesterday. All sorts of people have jumped in now. They say that defeating Annamalai is the single biggest joy for them on June 4th. But for me, I go into this seat with all humility, madam. This is a very important seat and one of our country's growth engine seat. And I go with all humility, and I just have to be an ambassador for Modi ji and represent the people there properly. So I'm not bothered by all the noise that is made. Neither am I going to be very aggressive. People can make all sorts of comments, but I'm very clear. The people of Coimbatore are very rational. They're very logical. They look very long term. And India's first finance minister came from Coimbatore, and it's a long history. So noises be noises, madam, but I'm very confident that this time BJP will deliver, not only in Coimbatore, in Tamil Nadu as well.
Noise, you say, because that is typical of Tamil Nadu politics. Lot of noise, lot of color, lot of everything is bigger than normal. Like what you see in other states. No, Tamil Nadu is like into two always.
Maybe into 3, 4 I'll keep it, madam. You are being very kind to us. So generally the drama, the stage, the movie culture, larger than life personalities, money power, muscle power. So Tamil Nadu is always like that. The scene is always grand. At the same time, the politics is always people do with humility also. There is also another end. But unfortunately, because of the noise, this set of people get drowned. But I believe 2024 is a very open field, more than any other elections in Tamil Nadu. 2024, I'm sure the rest of India will get to see the humble and people who are working in the grassroots, not bothered by the aura of money power, muscle power. I hope this election should portray a different side of Tamil Nadu politics to the rest of the country, madam.
Well, you were saying that it is, the humility and being humble, all that is coming. The accusation against your party is that, I'm not saying just Tamil Nadu, I'm saying nationally, the accusation everywhere is that it's become very arrogant because of being in power for 10 years. That humility, which was part of, a natural opposition party, which BJP used to be, like, being out of power, which was the humility comes from being out of power. But now, being in power for 2 terms, there is an arrogance in your party. Do you agree with that?
There is generally a mistaken assumption between confidence and aggression. And BJP, of course, is a confident party and still maintains its roots. It is not going to change from the ethos of what the party is. And Modi ji has changed a bit from being a pracharak to a chief minister to a prime minister now. He's still the same person. Maybe I think a world's leader, but is so down to the soil. So opposition parties want to mistake a confidence as an aggression or as a party that is going beyond from where it came from. I feel very sorry for them. And BJP is still the same. The opposition parties, instead of looking at their own performance, looking at setting their own house in order, they just want to attach these big labels to BJP. Again, 2024 elections will teach them a lesson, madam.
So now that you bring Mr. Modi and about Pracharak, I have to show you this video, which of Mr. Modi and you, which became so viral. So, like, what was happening out here? You tell me. He was patting you on the back, and then he held your hand, and it was like, "Bahut badhiya," he says. Like, I can lip sync. He said, "Bahut badhiya" out here, right? This was one thing which went like viral. So what happened there? Tell me what happened in this video.
This is the culmination of our yatra in Makkal, the last constituency, and the event was happening in Palladam. And Prime Minister was kind enough to come to attend the last concluding session of our yatra. I think it was a massive gathering of people, huge number. The passion, sheer passion and energy was so high. I haven't seen that in Tamil Nadu for a long time, madam. Modi ji knows Tamil Nadu. As a pracharak, he has stayed in Tamil Nadu. Ekta Yatra, he led from Tamil Nadu. And he has also visited Tamil Nadu at different points of time. So Modi ji is also seeing this. So I think the pat is not on my back, madam. It is for all the Karyakartas out there. So a lot of people have toiled. So he was just saying that you have put a lot of hard work. The cadres have put a lot of hard work. He was very happy. So I was clarifying this somewhere also that it is his way of showing his support to all the Karyakartas through me. And Modi ji, like, he always keeps setting the bar. Maybe the next video, if you see,
Yeah,
he
show
will
me
say
that
what
video.
next.
See this video. Okay, he's saying something, and you're saying yes, yes, and then you put your hand out there. So most people were saying that's something secretive, and then I said, okay, my first reaction was this is Annamalai ji's training as IPS officer. He's closed his lips so that no media can find out what he's seeing. No lip reading. This is your IPS training that is happening out here. So while we could figure out that Modi ji is saying bahut badhiya in the earlier video, what Annamalai is saying, nobody knows in this.
Madam, I don't know, it's a great privilege to sit with Modi ji and to just pick up that nuances, fine points. And it's so amazing. He sits on the stage, looks at people, and the kind of reading he does, just looks at people. He knows exactly what is happening. Energy, from where they have come, women, children. And I am really amazed by his eyesight. And many a times he finds out somebody in the crowd he will ask. A small child, a placard, something that is kept, even we can't just read what is happening. He will read, he will say what is it. So Modi ji is mind is always there. It is just there. It is there in the crowd. It is there in that area. And he will keep pointing, observing why somebody is standing. For example, that video is all about at the back, there is no covering and the hot sun. Is water being provided to them? And looks like there is a holding area. Is there enough entrances that is kept for people to walk in? So you'll be so amazed, a prime minister coming, sitting, and immediately his eye scans everything, sees whether everything is in order, people are comfortable. And this was more about whether people are given water there, the shade is not there, and looks like there is some hold up. So I don't know, madam. It comes only with Modi is Modi. There's no comparison. I don't know, madam.
Okay. In Coimbatore, he's been to Coimbatore before. For BJP, Coimbatore is in a very important place. I mean, with what happened with the blasts, the serial blasts. For them, it has been very important. But now, it's when we are looking at your constituency, DMK did not give the seat to the alliance. They have kept it with themselves. So how are you going to work out? What is your alliance? Has it fallen into place? The alliances that you
alliance is fallen into place, madam. All 39 seats we have declared yesterday. In the sense which is going to what party. BJP has declared the first list of candidates. Next will come soon. And we are ready. We are going to the battle. Absolutely ready. Now DMK played a very interesting game. So they knew that BJP is going to come hard. So they replaced the communist candidate with themselves, because communists will never leave Coimbatore. For a long time, Coimbatore has got communist MLAs. For a long time, it is decades.
Yeah.
For the very first time, DMK has taken that seat back, because DMK believes by sheer muscle power and money power, they can take that seat away from anybody who wants there.
Yeah, so I had this, the data in case, it's BJP, what was the Coimbatore seat 7 times, the left has won, Congress 5 times, DMK twice, BJP twice, and AIDMK once in the elections in the past, ever since.
You're right,
in that. So, but it's BJP has been second placed 3 times, 2019, 2014, 2004, these things. So yeah, you were saying, sorry.
Madam, like 7 last many times is communist, continuously. 2019, 2014 it is continuously a communist seat, except 2014 when ADMK won a 3-way fight. And this time DMK is brutally confident of its money power. They're coming to the battle only with money power. And we have to understand, madam, there are some seats in Coimbatore which are marker seats, in the sense, when we defeat somebody there, we are not defeating a candidate, we are defeating an ecosystem. And the whole ecosystem is at you. In Tamil Nadu, when the political change has to happen, you have to defeat the ecosystem. The candidates are mere tools of an ecosystem. And Coimbatore is one such seat, where the ecosystem is at play. And they'll completely come. The communist ecosystem is there. The DMK ecosystem is there. And
why has it taken you so long not to build an ecosystem of your own?
It is there, madam. 98, 99, if you see, it's a BJP seat. Then Coimbatore is also a very complex seat in a way. In a 3-way battle, it can go any which ways, because every party is strong there. Every party has got a certain assured vote base. So this time we are very confident that we will go one up, for the simple reason, our development has reached last 10 years, be it the industry, be it the beneficiaries of Coimbatore, and Modi ji's visit being the roadshow recently that happened in Coimbatore, massive roadshow. A very emotional outpouring by the people who came there. So this time we are very confident that we should deliver it.
So this road shows that Prime Minister Modi has now, if I was to play the devil's advocate, he had these even in Bengal and huge crowds came even for him there. Somehow and you know, Rahul Gandhi had his Nyaya Yatra and before that Bharat Jodo Yatra. Crowds were there too. But with Bharat Jodo, the crowds came, but they didn't vote for Rahul Gandhi. So somehow, you know, Indians just, I think the crowds come, but vote you can never be certain. There are many other factors that come into play, isn't it?
No, ma'am, I'm not denying that, but we have to understand when Modi ji comes as an opening batter, when he scores runs, just play a cricket analogy, IPL is starting today. When he gives you 200 runs in 30 overs or 27 overs, then the rest is you have to manage. When you have to reach 350, all is asking you manage 150 on your own. So that is the election management, meeting people, make sure people come out and vote, make sure our narrative is right, make sure our booth at the ground level is strong enough to meet all the voters who vote for BJP, bring them. So it's everywhere it is like Modi ji delivers, he opens, he gives you a sound board to stand and fight. So the Coimbatore is one such thing, Tamil Nadu is one such thing. The rest is election management. And states like UP and Madhya Pradesh with multiple winning elections, a cadre is built, leaders are built. For them, management is like a second skin. And for parties like BJP in Tamil Nadu, we are just learning and the leaders are coming in, they are getting exposed. And we are also becoming smarter, getting adapted, learning from our mistakes. So that's how I will say, madam. Everywhere Modi ji gives you that opening push, and be it Bengal, be it Tamil Nadu. But this time I'm confident that we have done our hard work over the last many years to build a strong team to catalyze Modi ji's charisma, vision, energy and translate over. The second part is more challenging. That's the challenge, madam.
When you did the Padayatra, you had 200 days, 234 constituencies. What were people coming and telling you in that? Did you feel between last year and this year in your interaction with people, did you see any change? Was it because firstly now everybody knows who you are? You've traveled the length and breadth of the state. Did you feel any change? What did people come and tell you?
I felt a lot of change. One, people came with a lot of, what to say, madam, demand, in the sense that only to family people they demand. For an outsider politician, they don't demand. You do this, why it is not happening, why you should do it. So more like a demand, which I felt very happy. So not from a request or not from an expectation, they went into the demand stage. I'm expecting you to do it, you should fix it, or your party should fix it. That we felt is a big change because they accepted us as one of their own. So this shift is more important. Unless they accept you in politics, madam, they will see you as like from agent and manager relationship. So it is more about accepting you as one of them. Second, madam, maybe this is the party's Padayatra is a unique yatra because it is not a straight line yatra, meaning that you start from point A and then you walk in the road, you reach point B. This is more, all 234 you go, stay for a night in 234. Predominantly, we must have stayed in 113 constituencies, 113 different places. And people see only the yatra, but we don't do 3-4 things apart from yatra on the same day. We meet a farmer, we go to a beneficiary's house, maybe have a food, talk with them, then meet the local groups. It could be a self-help group, it could be an NGO, it could be an auto driver union, it could be a business trade union group, or it could be a professional group. Sit with them, 150, 200 people, 1-2 hours you talk. So what it happens, madam, it roots the party to the ground. Your party gets rooted. And more importantly, wherever we go, the new people join, or the old people, the previous cadres get energized. So now, this yatra, we took as an opportunity to introduce all our leaders to that public. So we want to give confidence to our leaders. Look, there is so much crowd coming in for us. And you just have to be confident of yourself. So multiple things the yatra achieved. So if you have to put it in one line, that they accepted us as one of their own. That is very important. And this yatra has made it happen.
So I think what you're saying is that the curiosity over you and your party is over. Now it is, you see, because there is something called muscle memory also when you go to cast your vote. For so long, the muscle memory has been DMK, ADMK. Right now, to change that, it is not enough to find out about the party. You need to know about the party. So has it moved from curiosity stage to the demand stage, and you're confident enough that it can break the muscle memory?
You're right, madam. One, now BJP is not a party that is not to be treated well in Tamil Nadu. So that is gone. That we have crossed it long time back. Now stage number 2. accepting BJP as one among their one. Stage number 3 is evaluation. Oh, BJP is here, DMK is here, ADMK is here, let me evaluate. So this election is more evaluation. Next 28 days, with a honest, open mind, they're going to evaluate 3 parties. Because when the evaluation stage is not there, you are only in the stage 2, like just consideration. In the voting stage, you are not there. So this time is so important because our candidates matter, our manifesto matters, our narratives matter, because we have come to the evaluation stage now. So the very first time they do a sense of balance. Where is BJP? Where is them? Where is them? Oh, Modi ji is there. So Modi ji is great. But still through this candidate, can I get what I wanted for my constituency? So all those things happen. That is why I keep telling our people, look, Modi ji is an opening batsman. He has hit 6s and 4s. And he has given you 200 runs, he has gone. And again, he'll come back. But 150 is you have to score. And with all your hard work, we cannot just say, oh, Modi ji has come and everything is happening. Well, he has done his work. Now in the evaluation stage, we have to do our work. That's how I will put this election, madam.
So if you're doing your work, how many seats do you see?
Madam, if you want to ask me a number, I would say double digit, very honestly.
Okay.
And because BJP for the very first time, we are contesting in 19 on our own. 4 alliance parties in our symbol, meaning 23 in Lotus. And 16 alliance partners in their own symbol, they are contesting. 3-way fight is an interesting 3-way fight. You might ask me, why 10? When there is a strong third party, in a 3-way fight, that is how the party grows. In a 2-way fight, it is impossible for a third party to come in and make a mark. In a 3-way fight, we believe that we have votes of our own. Maybe if 15% vote 10 years back, maybe 20% vote couple of years back. Now the 10-20%, the curious, the neutrals, people who are watching, and they are shifting to BJP. So I'm very confident. A 3-way fight, I can confidently predict this number. In a 2-way fight, I might not be this confident, even within an alliance.
You know, since last year, you've been saying that BJP needs to have a footprint of its own. We can't keep riding on a regional parties thing. Yes, have an alliance, but we can't keep riding on their thing. We need to have our own footprint in the state. You've been saying this for a year. You said this in the podcast last time also. But tell me now, is that dream is getting fulfilled in the sense like one saw it in Uttar Pradesh, right? That it was either BSP or SP. Somewhere BJP carved a niche of its own, moved. Is that the model that you have for Tamil Nadu?
Yes, madam. Now, what is a brand identity? Every party, what is a brand identity? Tamil Nadu, when people should differentiate, you ask a common man, Anna, what is DMK? 3 things in his mind, her mind, maybe a sister or mother. What is ADMK? 3 things in his her mind. BJP, 3 things in their mind. So unless you don't